I have not. Hopefully he's got the right time zone. Do you want to ping him, Martha, just in case?
Yeah, I'm going to send him a message
Tell him
now.
everybody's on.
and we will go ahead and get.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. I'm pleased to welcome you today to the next webinar in our ABI-Live series. Today's webinar, which is hosted by ABI's Mediation Committee, is titled Mediation, Mega Cases and Avoidance Actions. Our panel of experts will provide guidance for attorney advocates on how to select mediators, prepare themselves and their clients for mediation, and how to formulate negotiating strategies for use in the mediation. During the webinar, if you have any questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. These questions will be sent directly to our panelists and addressed during the program. Also, if you need CLE for this program, please make sure you record the 3 CLE codes that will appear on your screen during the program. Today's program is being moderated by Scott Brown. Scott is a partner with Lewis Roca Rothgerber Christie in Phoenix, where he represents businesses in a broad array of transactions and litigation. His experience includes both in-house and outside counsel roles in loan origination and documentation, regulatory compliance, advising religious institutions, litigation in state and federal court, receiverships, and bankruptcies. Mr. Brown is a contributor to and co-founder of the ABI Journal's humor column, Chapter 8 Humor. So I bet he'll throw in some humor into this program as well. Welcome, Scott. Thanks so much to you and the other members of the panel for appearing on our program today. I'll let you go ahead and introduce the rest of the panel.
Thank you, Amy, very much. I appreciate that introduction. I don't know that we'll have a whole lot of humor today, but this will be a very, I think, entertaining and informative presentation. On the panel today are Frank Monaco and Leslie Burkhoff. And Frank, I'm going to introduce Frank briefly, and Leslie. Frank is of counsel with Gellert, Scully, Busenkel, and Brown. He's active in the American Bankruptcy Institute and currently serves as the co-chair of the Mediation Committee. He is also certified in business bankruptcy and has nearly 35 years of direct experience in this field, including representing debtors, creditors committees, and just about every other group of interested parties. He's been a Chapter 11 trustee, a liquidating trustee, and discovery master. Most importantly for today's purposes, Frank is a certified mediator, having completed the Institute of Conflict Management training course in 2004 and the North Carolina Dispute Resolution Commission certification process in 2016. His mediation skills are based on nearly 35 years' experience as a business, bankruptcy, and creditors' rights attorney, and he's an approved mediator for both bankruptcy court and bankruptcy appeals in the District of Delaware, and he's resolved over 100 disputes in the District of Delaware and as an arbitrator in the Delaware Superior Court. And Leslie is a partner with the firm of Morat, Hawk & Hamroff, where she serves as the chair of the firm's bankruptcy practice group, as well as advisory co-chair of the firm's Diversity and Inclusion Committee. Ms. Burkhoff concentrates her practice in the area of bankruptcy and restructuring litigation and corporate workouts, and she represents a variety of corporate debtors, trustees, creditors, and creditor committees, both nationally and locally. In addition to her practice, she frequently serves as a mediator and is on the mediation panels for the Eastern, Southern, and Northern Districts of the United States Bankruptcy Courts in New York and the United States Bankruptcy Courts in Delaware and the Eastern District of Pennsylvania, as well as the Commercial Mediation Panel for Nassau County. Ms. Burkhoff has also served as a court-appointed examiner and guardian ad litem in several bankruptcy cases, and she's also an inaugural member of the Chapter 11 Lawyers and Judges Advisory Committee for the United States Bankruptcy Court, Eastern District of New York, where she currently chairs the Subcommittee on Mediation. More recently, she was appointed to serve as the Business Law Section Liaison to the Dispute Resolution Section Advisory Council of the American Bar Association. So as you can tell, both Frank and Leslie have a lot of experience with mediation, both as negotiators and as mediators. I, on the other hand, have never been a mediator, hence I'm the moderator today. However, I've obviously been involved in a number of mediations as a negotiator. One thing that was left out of my introduction is I am admitted now in Colorado, New Mexico, and soon to be in Montana. So if you have any legal needs there, think of me. All three of us have been active on the ABI Mediation Committee. I said Frank was the chair. I think he's the chair of the education, co-chair of the education group for the Mediation Committee, as well as Scott Stewart. And Leslie's been very involved in that mediation committee as well, and all three of us contributed to a book called ABI's Bankruptcy Mediation that came out a couple of years ago. As the PowerPoint says, we're very grateful for Jay Anderson Little's contribution. He gave us permission to use some of his materials from a presentation he does called Don't Leave Money on the Table, with an advanced negotiating seminar of Mediation, Inc. So with that introduction, let's go ahead and get into the presentation. We're obviously going to talk about mediation and mega cases and avoidance actions. Our very first slide is, I'm going to pull up the presentation and hopefully I do it correctly here. Let's see.
Well, Scott, while you're talking, while you're fixing that slide, why don't we just jump in, because I know we only have so much time.
Sure.
And our first question was, why mediation? Frank, I'm going to give some thoughts on it, and then maybe you can share it, and our tech expert here can fix the mediation slides in the meantime. My view in terms of mediation, and it's probably not a unique view, is that it allows the participants in any litigation some flexibility and the ability to be creative in developing a result that works for them. I think we all realize that when a court rules and determines a matter, there's some level of constraint in terms of it could be a more black and white decision. Motion is granted, default is entered, judgment is fixed, or the like. The parties have the ability to arbitrate amongst themselves and say, well, if you give me X, I'll give you Y. We could pay it out over time. I could modify a contract. The court doesn't have the ability to do that. So it does allow parties to create their own destiny, if you would, and it's also an expeditious process. Frank, what do you think? What else would you add? Have we lost Frank?
Sorry. Yeah, and I agree with everything you said, and the costs and fees are usually a fraction of what it would be in litigation. So right there, that's an advantage. And also, it like you said, comes up with creative win-win solutions for both parties instead of a winner and a loser.
All right. Well, I think one of the things when we ask why mediation, I know recently I had a case in the Southern District of Florida where the question was simply answered by because we have to. There was already a procedures order entered in a case where my client got sued on a preference, and the order said you have to mediate within the first 60 days of being served with the complaint. Here's a list of mediators you can pick from. Oh, by the way, your client has to be there in person with settlement authority. Let's talk a little bit about that on slide 2. And those mega cases, multiple avoidance actions, procedure orders, are we forced to mediate sometimes, Leslie? And can we get out of those? Or what do you do in that situation?
Well, many of us, certainly on the panel and probably in the audience, have become familiar with these large mega cases, the Borders, the Metaldynes, the Lehman, 600, 700, 800 cases, preference actions, clawbacks, and the like, or other litigations that commenced during the course of the 11 by the liquidating trustee. And a lot of the lawyers over the last 5, 6, maybe even longer years have started entering, sometimes at an early stage, and sometimes before litigations even commence, a procedures order in order to manage the process. Now, this order could do anything from saying that there will be demand letters sent, that if it's not resolved, a complaint will be filed, and maybe answers don't have to be filed right away, but you must pick You must go to mediation. If the settlement negotiations don't work, you have to go to mediation. Oh, and by the way, you pick from this selection of panelists that have been pre-selected and approved and are attached on Exhibit A here too. You're channeled into a mediation process. That has had a tremendous success rate. In the Borders case, I believe there were close to 600 cases. And not one of them, I don't think Judge Glenn had to try one of them. I do know that the ALU and I think the Agape cases on Long Island exceeded that in number, and a similar process was conducted, and next to no trials happened. So they have phenomenal results. However, a lot of them have been challenged. A lot of times, the orders are entered, like I said, at the outset of the cases. So, for example, in the Madoff case, in Quebecor and a few other cases, Bayou, there were challenges by parties who were unhappy with the process. Some of the complaints included, hey, you brought this procedures order. I wasn't even a target yet. You hadn't even filed the complaint. I had no due process. I had no ability to, don't know whether this will or won't impact me. Now, some of these are retroactive, and some of these object to them at the beginning when the procedures orders are filed, which is, I don't know if I'll be a defendant. So there's primarily a procedural due process argument. So far, to the best of my knowledge, courts have rejected this and said, look, if you've come in at the time the motion's there, you clearly had notice. Whether or not you know you're a defendant is irrelevant. You certainly were able to show up. So that disposed of lack of notice. Sometimes there are pending statutes of limitations, and you have to file the complaint, but we don't want everybody litigating, cost-benefit analysis for the estate. And the goal is not to manipulate anybody. We want to get you to a point where you can resolve this without the cost of litigation. Query, I do know some judges have modified orders with limited panelists and said they can pick anybody that's off the list or anyone they agree upon. The flip side is there is an economic benefit to the same group of mediators dealing with 600 cases, because at some point in time you learn enough about the debtor that there is a historical knowledge that's a benefit. There's a chapter in our mediation book that you referred to before, which I happen to author, that goes into this in more detail if you're interested. But I think that covers it, at least from a high-level view for this point.
All right, let me transition to you a little bit, Frank. So in my situation, it was a successful mediation, even though we weren't happy about being forced into it. We only had 3 mediators we could pick from. And how do you pick, Frank, from a mediator, whether it's ones you don't know at all and you have a list from a court, or you're trying to pick one on your own that a court's not requiring you to pick?
Well, there's a number of factors lawyers should be looking at in selecting a mediator. First of all, training. The ABI St. John's Bankruptcy Mediation Training is an excellent course. It's offered every year. But there are also a lot of good state court mediation training courses, so certainly that is one factor. A background in bankruptcy, but as a practical matter, you rarely see a mediator who doesn't have a background in bankruptcy. In terms of a panel of mediators to pick from, every jurisdiction has different requirements in terms of certification and experience. And just a FYI, I'm part of the Delaware Bankruptcy Court Mediation Rules Committee, and they're a process of amending their rules to clarify, the certification requirements for mediators. Then there's also whether or not to pick a judge versus an attorney. This is a rather sometimes controversial issue because there's been at least a knock against former and sometimes current judges that because they're trained to make decisions, they aren't always in a facilitator mood. But on the other hand, there are a lot of complicated situations that cry out for an adult in the room, and having a judge can be invaluable in terms of if there's a case we've got strong-willed parties. And finally,
the judge is free, right?
That's right. The judge is free.
Another point.
And every jurisdiction is different. For instance, I know in North Carolina, in the bankruptcy court, at least in the Eastern District, they the only time another judge will get involved is when a practitioner mediator has sort of failed in the opening round to get it settled. And then finally, you need to know the style and personality of a mediator. And sometimes this is word of mouth, but the traits that I think you should look for are persistence, patience, listening skills are critical, having a sense of humor to diffuse tense situations. And I think a mediator needs to be a bit of an amateur psychologist and know what motivates people. And obviously, experience and knowledge of the bankruptcy industry is very helpful. But I would just leave with the practitioners and the audience that you really need to do some research. If you don't know your mediator and haven't used that mediator before, Google them. Look up on their website and see what you can glean from that. And it's amazing how many times lawyers don't do that. Mediators will often Google attorneys that they don't know. So Leslie, I don't know if you have anything to add to that.
Well, the only thing that I would add, and I think you really covered almost all of it, is when we were talking about, whether or not to use a sitting judge or a retired judge, and you're right, sometimes the free is a big push for it. But there's one or two other thoughts on using a sitting judge, and that these are fears. I, for what it's worth, think they are unfounded fears, but to the extent that our audience is identifying going through thought process here, I've heard from some people they're always worried that the judge is going to talk. They're going to call up the other judge that's handling the case and say, hey, let me tell you what's going on. Well, any judge that's conducting a mediation is not doing that. That defies the purpose of mediation, the integrity of the process. So I really would be shocked to hear that. The other concern is that, well, if I'm staunch in my position and I'm entrenched and I am perhaps aggressive in my negotiating posture, will the judge hearing this take that to heart and perhaps use against me in the next case that I have before them? I don't know that that's the case. I think judges recognize you're zealous advocates and you're representing clients. And if you're aggressive and harsh, you may be aggressive and harsh at all points. So maybe it's no different than your natural style. But I did want to throw that out there.
All right, thank you. Let's go on to the next couple of slides. We have 3 slides that deal with the question of what do great negotiators do. And they're kind of broken out into 3 pieces. One is it deals with preparation. The second one deals with how do you work with the mediator effectively. And the third one is developing the right mindset for mediation. And Leslie, why don't you go ahead and keep talking and entertaining us and tell us what you think about what you should do to prepare as a negotiator.
Absolutely. And I'm going to emphasize this a lot because it really concerns me. I've been doing mediation for a very long time, and I've worked with some wonderful lawyers who advocate very nicely for their clients, some in and outside of the bankruptcy process. But sometimes lawyers forget, that this is no different than going to court. You need to prepare. And you need to think about this not as a litigation case, but you have to say, if I want my mediation to work, if I want to avoid the cost of litigation and the like, then I have to figure out what it is that I need to have available to me for the mediation to share with the other side or the like. And I need to discuss with the mediator, perhaps I need some interim discovery because there's been no discovery in the process. And I need this documentation, or I need to bring stuff with me or have the right people available so that I can educate everybody, because this is a persuasive process. You also have to tell your client what's going on. They have to understand what this is. I am sometimes shocked as a mediator to realize it's the first time the client is learning about a caucus, a joint caucus, a separate caucus, confidentiality, or the like. I also would ask a mediator, what do they do when they run the process? How are they working it? So you're as well prepared. And again, your client is educated, but if you have a very strong feeling about a joint session as to why that's good or bad, you should be laying that out and discussing it with the mediator in advance, and perhaps the adverse lawyer. And there will be an upcoming article in January ABI on use of joint sessions. I'm just going to put a plug in there for that.
Thank you. And there's also a little bullet point at the very bottom called position versus interest bargaining, and
Correct.
we're going to talk about that a lot later on, so we'll dig into that in a little bit. Frank, the next slide talks about using the mediator effectively. How should negotiators use a mediator?
Well, you should use a mediator as another tool in your toolbox. I think to have a successful mediation, you really do need to have an exchange of information. First of all, I think, and not all mediators do this, but I think you should insist on a initial call with the mediator and the attorney for the other side in terms of just making sure everything's scheduled, the logistics are right, the information's being exchanged to deal with preliminary issues, and that way you streamline the process, and these things aren't coming up at the opening session of the mediation conference, and you can pretty much, if you have this initial call and you work these things through, use your mediator almost as an arbitrator for some of these issues, and it'll really streamline the process. You can also use the mediator to manage your client's expectations. I think lawyers are often reluctant to convey bad news, or they tend to downplay the risks and the cost, and you can use the mediator to convey the messages that maybe it would be better coming from a third-party neutral as opposed from the advocate. Also, don't be afraid to pick up the phone and call the mediator and use the mediator as a sounding board for ideas. A mediator can often help you formulate your plan and your communications to the other side. And of course, and we'll talk about this down the road, but the clients are often governed by strong emotions in the case, and the attorneys, they don't even realize it, but they're invested with their client's position, and sometimes can be emotional as well. Use the mediator, recognize this, and use the mediator to be a calming effect on your client, and get the mediator to help the client formulate a logical business solution.
Right.
The next slide. Go ahead, Leslie.
As I was jumping to the next slide, but thank you for the prompt. In addition to that, all of those are great thoughts and very, very important. One other concept: you need to develop a negotiator's mindset. Take off your litigation hat. Coming in, pounding the table, telling the other side why they're just plain stupid and they don't understand the law and how you're going to beat them in court is not the way to get things done. You really should study the art of negotiation. It is very different than litigation. There's an old saying, you get more flies with honey. There's a level of truth to that, and that means be civil, be pleasant, but you want the other side to buy into a part of it, your view of the case, and why there's a win-win for everybody if we can work out a deal and we all come out with a little bit ahead, maybe a little bit behind. Treat the other side with respect, the lawyer, the client, and the mediator. Make sure, like we said before, your client is prepared. You don't want them to be put on the spot. Plain English is really, really important. Let's not sit there and use all sorts of terms, because you want the clients to follow what's going on through the process. You want them to buy into it, understand, and you really want them to be contributors. This may be the only time that your clients, outside a deposition or being on a witness stand, are going to be able to speak independently and somewhat freely in a case. And it's their chance to tell their view, what's important, what they need, and why they need to get to X in order to resolve this.
And the other thing I would add to that is, in terms of studying the subject of negotiation, I would commend to everyone's reading a book called Getting to Yes, which is about negotiating. And it's written by Roger Fisher and William Ury. Very, very well done, and has some good practical tips in the art of negotiation. And I would commend that to everyone's reading. And again, just to make the point that Leslie made, be cognizant of the language that you're using. I'll give you an example. Say the other side's being utterly ridiculous. Well, the word utterly doesn't add anything, and ridiculous is a pejorative term. Frame it in a way that is not threatening and more constructive. For instance, it would make sense to settle for these reasons and list them. So that was my thoughts on developing a negotiator's mindset.
Yeah, I think it's very useful information. I had a mediation a couple of years ago, and my co-counsel came into the mediation with an hour-long PowerPoint explaining why the other side's wrong and will go to jail if they continue to fight us on our claims. And needless to say, we did not settle at that mediation. But to be fair, sometimes there's an expectation from the client to put on a show for the client. They want a tough lawyer. They want the meanest person in town, and when you go to a mediation, that's obviously not going to be effective and result in a good settlement for either side. So some good pointers there. Well, let's transition. The next two slides talk about planning for mediation. The first slide talks about exchanging information. And in my case, a preference case where we had 60 days to get ready for a mediation and really no time to do any discovery. We really had to do more informal discovery and disclosure because there's no way to settle sometimes a preference claim if you aren't exchanging information. Leslie, what are some of your experiences with that?
Well, you're right. A lot of times, and sometimes procedurally, as we indicated before, it happens early, and therefore they haven't exchanged anything. I really do encourage the parties to share information. It's not that somebody's getting a leg up. It's you're educating them why you have a defense. So sometimes we'll talk about having an informal. Tell us what you think you need to evaluate their claim or their affirmative defense, and make sure that you get it to them in time so that they can absorb it. You don't want to say, here's 12 flow charts and spreadsheets. Here you go. Why don't we all sit here while you wait and absorb them and read them? And they may not have the right people there to do that. So the more prepared you are, the more flexible you can be through the process. So that's really important. And the other thing is you should be taking the information that you get, and the best way is to have a plan, which includes your best outcome, your worst outcome, what you can live with, what could happen. And again, having this information is going to get you in a position that you can better evaluate what's going on and how you should proceed.
And the only thing I agree with everything that Leslie said. There's mediation by ambush just doesn't work. The more information about legal theories and facts that each party has, the better position they will to evaluate each other's position. And in the world of preferences, one thing that I've found is that each party, I know, should do their own ordinary course business and new value analysis. I've gotten this excuse from the plaintiffs' lawyers, well, it's their affirmative defense and it's up to them. But I think each side needs to do their own. And the other thing I would recommend is know your judge and how they rule on certain methodologies, particularly in preference defense. I've had several situations where lawyers were in love with their case and their methodology and their statistics, and I said, well, have you read Judge so-and-so's opinion where, he used this method and found that 5 days was the difference was not between pre-preference and preference period was not significant. And, I think it's important to know thy judge.
Thanks, and that kind of leads into the next slide, which is doing a risk analysis, and part of that is knowing thy judge, as Frank puts it. What are some other things you should be looking at, some other risks you should be assessing? I know for litigation you do a risk analysis. For a mediation, how do you do that, and what's effective?
Well, I think I'm sorry. I think this is probably a detailed discussion of this is beyond the scope of this webinar, but it is a very important one. Everyone needs to do what they call a risk analysis tree, and there's plenty of articles have been written about that. And what you do is you handicap each step of the way, whether it's summary judgment or motion to dismiss, and through trial, what the percentage of winning and losing is. And you apply these percentages along the way, and deduct your cost. You also have to look at collectability, and you come up with a more realistic number in terms of your best and worst case scenario.
Leslie?
Yeah, no, I think that that's very, very important, and I know, Scott, you commented that some of this is litigation, but it's really no different. You have to really think about the fact, and that's what the risk analysis tree lets you do, what's happening above and beyond what might happen with an adverse ruling. All of the lost focus, time out of the office, money, risk, reputation, there's a lot that goes into it, and I think Frank covered most of it, but those are a few other things that I would just highlight as well.
I just got a good question I think that fits in right here. Discuss the benefits and drawbacks in disclosing an expert report to the opposing party mediation, especially early in the case. For example, the benefit may be showing that your case is strong. The drawback may be the opposing party has ample opportunity to pick apart the report if the case does not settle. What do you think, Frank, and what do you think, Leslie?
Well, I don't see any problem with that. Your expert is putting their best foot forward for you, and you want to emphasize the strengths of your case and make the other side think about, what their weaknesses might be. So and it's going to come out sooner or later anyway if it goes to trial. So I don't see much of a downside for doing that.
And I would agree with Frank. I don't know where your downside is. You've picked this expert. You think this person best is capable of highlighting why you're right. If someone else is going to point out and pick it apart and show you're wrong, well, there's two options. One, if you disagree with them, you'll have a discussion during the mediation. And remember, the report is not evidence. They can look through it. You could always choose to modify how you're approaching your case, maybe ask for additional discovery that allows you to fix holes that are in your report. Obviously, it's out there, and it's certainly otherwise discoverable. But better that you know it sooner than later. If it hasn't settled and they're going to pick apart your report, then you just may have problems with your position. But you're going to get there anyway. So I don't see an issue with it.
Yeah, I had a case recently where an expert report got blown up during an expert deposition, so it's better to learn it at mediation than when they're being deposed. Okay, the next few slides, we're going to talk about the mediation conference. We have a slide on that, and then we're going to talk about some of the different negotiating posturing that you can do at a mediation, some that are unsuccessful and some of the successful. So let's talk briefly, both Frank and Leslie, about the mediation conference, what you like to do, how you like it to proceed.
Well, I'll speak to the parties ahead of time. Generally, the lawyers, sometimes I'll do single calls with lawyer and client, but I usually do a joint lawyer call. And I emphasize 1,000,000 times, and I emphasize it again in pre-emails and during the mediation itself, it should be a settlement-focused initial conference. I'll explain the rules of the mediation. I'll make sure the clients know what's going on and how it's going to run. Of course, no matter how many times I say to people, don't assume that if I'm sitting in the other side with the other side for 20 minutes longer than you, it means because I love them and I think their position is great. I'm not deciding anything anyway. And for all you know, I'm telling them or trying to convince them that they're really out in left field on this. So try not to conjecture. So I'll lay all those ground rules, and I'll emphasize the persuasiveness of it, and that I want everybody to be civil, proceed in a cooperative, settlement-focused fashion. That's really, the highlights of it for me.
And I'm not a big proponent of opening statements. I prefer dialogue to argument, and some of that is what I call the pebble theory. You try to find different issues where you can agree upon, and define the issues that you can't, and talk about them. There may be misunderstandings or things that need to be clarified. And when you have a conversation as opposed to an argument, I think it sets the tone, for the whole mediation going forward. And a lot of times it's the first time that the clients have seen each other in person, and it's a good way to sort of humanize the other side. Another, I think, critical thing at the beginning is, the tone of voice you use and your body language. One thing that you need to be aware of is, and I've seen this happen, lawyers, instead of, talking in a matter-of-fact tone of voice, are, using a argumentative tone and staring at the other side's client. Well, that's, even in the animal world, that's perceived as a hostile action. So you should be looking at the mediator or your opponent, as opposed to the client. So this is some tips that I would suggest at the opening session.
All right, let's talk about a couple different types of negotiation. These next couple of slides are interesting to me as a negotiator, because I can definitely see myself fitting into one of these roles, that what we call the position-based bargaining. And I didn't know there was a name for it. I didn't realize I was falling into this maybe psychological trap. But there's position-based bargaining, and then there's what we call interest-based negotiating. And I guess the difference between bargaining and negotiating is maybe the key factor there. But if you could tell us briefly, Frank, what is position-based bargaining, and Leslie, tell us briefly what interest-based negotiating is, and then we'll get into more detail about those types of styles of negotiation.
Okay. Usually position-based bargaining is about money. It's a give-and-take process, and the parties, initially stake out their positions. And this is a hard way to get to a resolution, because the parties get entrenched in their positions. They tend to emphasize the strength of their positions and the weaknesses of the other side, and it creates impasse, which we'll talk about a little later on. And so, the only way that I've been able to get the parties off that is sort of emphasize the cost and risk to both sides. But it can be a difficult way of negotiating and coming to a resolution.
And interest-based negotiation is definitely different. You're understanding what matters to the client. It's what they need versus they want. So you're reframing your negotiation. It's not so much bargaining in terms of chits across the table. It's problem solving. It's saying what each side needs. It's identifying them in a clear fashion. We talk up there on our screens about a win-win situation or solution, and it's a more collaborative manner in which to approach the process. It doesn't work in every situation. There are some that really, it's not that you're not cooperative and settlement focused, but there may not be the kind of ongoing business relationship between the parties that you can really do it in a traditional fashion. But that's sort of it in a nutshell. We're going to talk a lot about positional bargaining, and we'll come back to interest-based in a little while.
Yeah, let's go to the next slide. It says settlement of civil litigation is dominated by positional bargaining, and that certainly is the case. You're talking about dollars a lot of the time. Frank or Leslie, what are some things when you're a mediator, you start to see signs of this type of positional bargaining? What are some traps the lawyers or the negotiators start to fall into?
Well, I think even leading up to the mediation conference, one of the traps that parties fall into is that they don't perform the proper risk analysis. They don't, in other words, handicap their case. And so they come up with these almost artificial and arbitrary bottom lines, and that don't really have a basis in a business solution or what the risk and cost are. And what happens is that both parties will say, well, I've reached my bottom line, and there's this delta of X, and the parties, from a perception standpoint, feel that they can't move. And it's very, very difficult to get a case settled when the parties have reached what they both consider their bottom lines that may be totally arbitrary. So that's a challenge for the mediators, but it's a challenge for the parties, because I think if they have a more fluid perception of what their bottom line is, and they handicap and do the risk analysis, it's less likely to happen.
All right. The next two slides talk about the death spiral of position-based bargaining. So slide number 13 is the chart, and I think we owe this chart thanks to Mr. J. Anderson Little. But the next slide talks more in detail about that. Leslie, you want to talk about the death spiral and why it's called a death spiral?
It's a great name. It almost reminds me of something we call, it really is almost shuttle diplomacy. You start going back and forth by numbers, but what everybody starts to do is they start to evaluate or guesstimate what is going on as a result of the moves. So plaintiff will take a position and say, tell you what, we're settling this at 80%. But, you know, they're really doing it at 60 to 65%. And then the defendant will say, well, you don't really know how to value your case. That's ridiculous. You people are out there. You're not making any sense. And you're wasting my time. So I'm going to be ridiculous in my offer. I'm going to send him a message. I'm going to do, you know, a really minimal. He's out in left field, he's out in the stratosphere, or she's out in the stratosphere. So I'm sending a message back, and I'm going to start at the bare minimum. And you start to engage in, it's not just position-based because it's numbers, but it becomes reactive. And suddenly the dynamic between the parties literally starts to be not so much the risk analysis tree that Frank talked about and we mentioned earlier, but it starts to become, I'm sending a message because I just want you to know on the other side that I believe in my case, and I'm going to let you know by moving ever so slowly that you better get real or we're never getting anywhere. And it's not a good position to find people in. It really doesn't help the process. Thanks,
and I think that's covers slide 13 and 14. So let's skip to slide 15. Talks about three important insights.
We have a question, Scott.
Oh yeah, we do have a question. Let's see. Mega cases tend to be filed in a few concentrated jurisdictions. Avoidance defendants, however, are spread far and wide, often well outside the debtor's chosen forum. Any comments on using technology to facilitate mediation to reduce defendant expense by parties participating remotely, etc.? Frank, what do you think about that? Leslie or Frank?
Well, I've had, this is a tricky question, and it's something that the mediators and the courts have wrestled with. One way to get around it is, you know, doing it by, you know, video conference. But, you know, often there's no substitute for having the party there in person. It's a lot harder to say no when you're sitting across the table and there's time pressures and the expense of having to be out there. But having said that, I think for smaller cases, and for instance in Delaware, there's what they call a small preference exception for preference actions under $75,000, where your representative can show up and the client can be available by phone. So I think, you know, there are certainly ways of getting around that. I think for bigger cases, and in my mind, anything over 6 figures is a big case, the parties should probably be there in person. But for smaller cases, I think there's ways to accommodate parties to save expenses. And what I tell people is use what you just saved in money as currency in terms of, you know, getting a settlement.
I think I'd only add 2 quick comments on that. One is, and I agree with Frank on the being around the table, seeing each other. You lose something when the parties aren't there. That being said, in certain circumstances and at the request of counsel, and utilizing that chit, as you said, that you can throw that dollar save into the process, I've, with permission, occasionally attempted on a couple of times, and it's worked, to at least say, hey, we're going to set a mediation date. It's there. We all agree you have to be there under the court order. If we can facilitate a resolution through some phone calls, joint calls and then separate calls, great, and that's wonderful, and we'll give it a shot. And sometimes it's worked. And sometimes the thought of having to get on a plane for both sides is enough of a deterrent to say, you know, I'm only so far away, but I really don't want to have to go in person, lose a day, spend the money, risk this unwinding. I'd rather just get it done. And the other last thing is I was at a meeting of the New York State Bar yesterday of their ADR committee, and there are a couple of books out there on online mediation. There's a treatise that's been published. I don't know the author offhand, recent, and in a couple of sessions we're actually going to have a presentation on that. So it's out there. I just don't know that I can fully grasp the concept of doing it literally through the computer. To me, that makes it so impersonal, and I think you lose a lot, but I'm prepared to be educated differently.
Thank you. Let's maneuver back to the death spiral and position-based bargaining. We have a couple more slides on that. For the interest of time, let's go to slide 16, which talks about the opportunities for impasse are numerous. Frank, what are some of those opportunities for impasse you see? And the next slide deals briefly with, again, with the death spiral. What are some ways you spot impasses, and how do you deal with them?
Well, I think, one thing that the book Getting to Yes makes the point of right off the bat is, separate people from the problem. And you need to understand that there are emotional aspects and perceptions involved in this that are not logical. And one of the things we talked about is, these incremental, very small incremental moves in reaction to the other party. What I would say is have a game plan and follow your game plan. If in terms of the number you want to get to and your increments, no matter what the other side does. That's number one. Also, when you make proposals, do them in a way that they convey a message. You'll see, they're not serious. They're not here in good faith. When you attach those types of messages to your proposal, they don't even hear the number. They hear the pejorative and ad hominem, missives that are being thrown at them. And what I would suggest is, instead of saying, we can't accept this because it's ridiculous, say we can't accept this because it doesn't cover our costs. It doesn't even meet our worst case scenario. So, send a clear message to the other side with the proposal, and do it in a way that's constructive.
All right. Leslie, any thoughts on that? We have a question about how do you pull out of the death spiral, and we've got a couple of slides coming up on that. But before we leave the actual death spiral itself, any other further thoughts on that, Leslie?
I think that, Frank's covered a lot of it. The other thing that you want people to focus on while they're together, even if people get a little hot under the collar, sometimes people are closer than they really realize. And when the mediator is encouraging you to continue and to sort of move past and look at separate the people from the problem, as Frank said, you need to put your trust in the mediator. Their goal is to get it done and get it resolved. And while they're not sharing the confidences of other side, a strong encouragement from them to keep the process moving forward is not intended to waste time. It's working towards a resolution that they can see in their mind could possibly happen. So I think that's the only thing I would add is, allow the mediator to guide you back on the right path to get to a good end result.
All right, thank you.
And I would add one other thing, Scott, to this, and this is sort of extreme reactions, and I've seen it all, people running the elevator, packing up their things, a lot of theatrics, demanding that people bid against themselves and lowball. I think before you utter those, do those kind of acts or utter those words, you need to have a little bit of empathy. You need to put yourself on the receiving end of those types of responses and how you would react and how you would like it. So I think if people, and again, this gets back to Leslie's points about civility, if you put yourself in the other party's position, I think it always helps, get things resolved.
And Scott, we have a question pop up that might actually be appropriate right now, if I can.
Sure.
The question was, during interaction with the mediator, how do you manage attorneys who are trying to, quote, manage the mediator to push their position to gain favor? First of all, the mediator isn't deciding anything. We're not taking sides. We don't necessarily like one side better than the other. A good mediator, if you think that they're listening to you because they like you and they like your position, they're doing the same thing on the other side. Our role is to listen, to guide, to facilitate, to sometimes evaluate. We'll talk about that. And so, you know, as a mediator, if you're trying to, for lack of a better word, brown nose, we all know what it is. We're not going to call you on it. Our goal is to see past that, and our goal is to say, that's great, that's lovely, now let's talk about where we're moving from here. Mediators that are, quote, well, could be managed and the like, it's wrong profession. Shouldn't be doing mediation, but I will tell you that in large part, I very rarely have seen that, if at all.
Thank you. So let's go back to the question before that one. It says, how do you break the death spiral and get people moving in a better direction? And we have a couple slides 18 and 19, that talk a little bit about that. And let's start with slide 18. Leslie, how do you avoid the death spiral? What are some things you do?
Well, I think it goes back to, again, you know, make sure you help people as a mediator identify when you're being reactive. And you as the advocate have to listen. Try and take that litigator's hat off. Try and take the adversarial. Your goal in a mediation is to wear a different hat and to advance the purpose of your client and construct proposals that are well-formed. Communicate your range of settlement. Be careful how you're saying things to the other side, because communication is important. So you wanted to say, look, you know, yes, maybe you moved $5,000 because I came up 5. I'm here to settle the case. You know what? I'm going to move $10,000 forward because I'm looking to resolve the matter. I'm in good faith, and you can even say, and I think it's a good way to do it, which is, and by the way, I'm doing that because, tie it back to the facts. We've all acknowledged that risk is on this side or that side, or that we've acknowledged that this, if we're talking traditional clawbacks or preferences, new value should be applied. I think I have a stronger position on this. I recognize it'll cost me money, and this is why I'm moving forward, but I want to get it done. And it's how you frame it.
Okay, and slide 19 gets into a little bit more detail about the death spiral and how to avoid it. Frank, what are some thoughts that you have?
Well, I already talked about, you know, the need to be empathetic about, you know, extreme reactions that just are going to put the kibosh on the settlement. But one other thought I have is, and this gets back to something I said previously, is that, you know, people
enter your access code followed by the pound. To enable audio controls, please enter your audio PIN followed by the pound or hash sign. If you do not have a PIN, just press pound or hash.
Oh my God. Let me ask her. Scott and I are on the.
We'll be on in a sec, Amy.
Okay.
Talk to the panelists, Amy, just to make sure we can hear
Hey
you.
guys, it's Amy. Can you hear me? They can't hear me.
I had to unmute.
Okay,
you. Go
can you, hey, this is Amy. Can you guys hear me okay?
Yeah. I
Okay,
can hear
great.
you.
I'm going to get on and apologize profusely about the technical difficulties, and then who should I hand it off to?
Leslie was going to go next on slide 20, I think. So
Okay.
if you want to
Yeah.
pull slide
Is-
20, and Leslie will start off.
Okay, so slide 20, and then
Yep.
I think people are starting to come back on.
I'm going to try to begin broadcast, so
Okay.
if we get quiet, you'll hear it start.
Okay, great.
Star one again. I don't have audio control, do I? There it is, slide 3.
getting emails from people.
The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. This is Amy Quackenboss again. We're so sorry for the technical difficulty we had, and we are now back online. And thank you again for joining us. And I'm going to hand it back to Leslie, and she's going to pick up where we left off.
Great. Thank you so much, Amy. And we're going to run over a little on our 2:15 time, especially if there are questions, if necessary, to make sure everybody gets accommodated. And thank you for those that stayed on the line at that point or are dialing back in. But we were at a good breaking point anyway, although we didn't do that for emphasis. We want to sort of talk about the fact that everything we just went over through all of our various slides really could be encapsulated in 4 important things that we'd like you to consider and remember about movement, messages, communication. Movement breeds movement. If you hold your line, the other side holds your line, people become entrenched, and you don't move forward. And that doesn't do anyone any good. So movement of any kind is helpful, and a mediator will encourage you to do that. But remember, and I mentioned it earlier, a complete message about the proper range of settlement occurs over a series of moves. Don't judge it by, well, I've moved 6 times, we're done, they're moving too slow. There could be a variety of issues at play. It could even be one issue at play. It can take 30 moves, it could take 5 moves, it could take 2 moves. It doesn't matter and shouldn't be judged that way. Movement is movement, and as long as you're moving forward in a positive fashion, that's good. A decrease in movement could be a signal that one's slowing down or you're getting to the end. You start seeing those smaller numbers. They don't move as quickly, or if they move quickly, it's a little dollars and we're just sort of wrapping up. You're communicating things in some respect. But I think it's also important, and again, I did highlight this earlier, and I'm going to emphasize it. The best way for the other side to understand why you're moving in the fashion you're moving is to add verbiage to how you're moving. I am making progress, and I'm making another good faith proposal of X dollars on this particular aspect of the mediation. Why? Because I think we both acknowledge that there's more risk for both of us. I can't give any more on the other one. And why can't I give on it? Because you've told me that you think, and I've acknowledged that that's a good, solid position. We both know I can litigate that quickly or get it resolved by motion practice. I can only, in my risk tree, allocate so much dollars, cents, and business time away to that particular aspect. Let people understand on the other side where you are coming from and why you are moving the way you're moving. It is really much more helpful.
All right, Frank, let's go to the next slide. This is slide 21, and we're finally getting to the gold standard of negotiating at a mediation, the interest-based model. How do you turn arguing and bargaining into creative problem-solving mediation for mutual gain, or what we call interest-based negotiating?
Well, as we discussed before, positional bargaining, everybody goes away a little unhappy, and it's much more about money and managing expectations and trying to convince people it's not really about winners and losers. Whereas interest-based negotiations, we all get what we need. And I think the key to having a successful interest-based negotiation are a couple of things. I think you need to be a good listener in terms of what the other side is saying. The lawyers need to be good listeners of what their clients want. And let me give you an example. When I took the North Carolina State Training Certification Program, there was a lot of role-playing, and maybe a lot of people in the audience have done this, but you were required to be in the role of the client. And what I found was that my lawyers weren't really listening to me. They were more interested in what they thought I wanted to hear, and that was very frustrating. And I think the lawyers need to put themselves in not only a position of what the other side may want, but what their own client wants. And also, the other, I think, key is creating multiple options. If Plan A doesn't work, what about Plan B? If money's involved, which it usually is, can you tie in installments that are related to one party's cash flow? So you constantly have to think outside the box, and not just in terms of one number. There's a lot of room for different types of solutions and creativity.
Thank you.
Agree.
So Leslie, we have up slide 22. What else do you have to add to the stages of the negotiation process?
Well, let's go back to the fact that you're understanding the goals of the sides, not what they want, it's what they need. And what do they want to achieve out of this? So when you as the mediator are meeting in separate caucus, you should use open questions to learn, and you as the advocate, quite frankly, in your prep session, should really try and understand what your client needs. In fact, clients will often come in and complain and say, I need this, I need that. As a true business advisor, which a good bankruptcy lawyer should be, that may not really be what they need. You may have to look at it and analyze and say, I hear what you're saying, but really wouldn't this be helpful? Wouldn't this work for you best? Or make sure you're really listening to your client. You may want a nice dollar amount and success rate, but maybe it's really more important for them to walk out with a continuing business relationship and an offset against future pricing. Make sure in early prep you and the client are on the same page about what the goals are, about what the needs are, and what the real problem is to be resolved. And when you're in open session, joint session, and private caucus, try and really be facile in summarizing what your client's really looking for and how they want to achieve it. And as the mediator, in order to establish that communication exists and that you've really heard what's being said, summarizing back what you think that they've established for you and what they're concerned about and what they'll allow you to say to the other side is a really important part of the process. And that takes us
Frank,
pretty much
anything else
to
to add before we go to the last slide?
No, I think picking up on something Leslie said, I think it's important, rather than make statements, is to ask questions, because the answers are what really important sometimes, instead of making statements to the other side. Ask a question and find out what it is that they need.
All right, let's go to the last slide, settlement. So we've done it. We've resolved the matter of mediation. Now we need to document it and make sure various issues are covered as part of the settlement, so we don't come back later and realize, hey, we forgot to talk about that. And may be an important issue that blows up what was accomplished at the mediation. One of the things on the list I'll take quickly, and then I'll turn it over to Frank to cover the rest, preserving claims against third parties. For me, that's can be an important thing. I represent a credit card company that gets sued quite often for preferences, and in some situations it's an individual who has a credit card in their name, and they also have a business, and they're using business funds to pay off their own individual card. And so when the business goes into bankruptcy, the trustee says, hey, why was the business using his funds to pay the individual or the principal's personal debt? Sometimes it was personal debt, sometimes it was company debt. That aside, we want the ability, if we're paying money back to the trustee because there was a fraudulent transfer, we want the ability to go after third parties. And so we'll usually make sure that the trustee's aware of that, and we will usually put something in the settlement agreement to make sure the release isn't so broad that we're releasing claims against other parties that may not be part of the mediation, at least not sitting at the table. What else, Frank, would you recommend?
Well, from a settlement standpoint, I realize that parties have suffered mediation fatigue. They're worn out. It's been a long day, but documenting the deal is critical, and you just have to put the time in it. Both lawyers need to sit down and put pen to paper and make sure they've covered the critical points so that there's not an issue coming back. One other thing, and this is really sort of beginning and the end, if you have a preference action and you have the defendant has a 502H claim, realize that the payout to unsecureds could be currency. So realize, waiving it or keeping it can have, an effect on your recovery. And also know how the payoff or how your claim could affect the payoff if it's a big claim. And one of the first questions that I always ask at the opening session, if it's a preference action, is what is the payout to unsecured creditors? If it's 20%, that's significant. So waiving, a 502H claim is meaningful. And you also need to understand if there's multiple debtors, the payout may be different depending on what debtor entity it is. So I've had a number of mediations where the payout, it varies from maybe 1 to 30% depending on the debtor. So understand that too as well, which entity is involved, and something that it probably should be discussed at the front end, but understand what you might be giving up with a 502H waiver.
Leslie, anything to add to that?
I don't have anything specifically. I think we've covered a lot. Obviously, I will encourage people to purchase the mediation book published by the ABI, which we were all contributors to. I'd encourage you also to read Mediation Matters, which is the column that I edit in the ABI and for which many of us are contributors. Or if you think that you'd like to contribute to that column, feel free to reach out to me. I'm happy to consider other authors and run them up the flagpole at ABI. And I hope everybody learned something new at least, or had something reinforced for them in terms of mediation, which we all agree is an ever-growing area in many different courts besides bankruptcy.
All right, thank you. I don't see any pending questions. We seem to have some momentum with the questions before we blacked out, but I don't see any now. So we will turn it back over to the ABI.
Great. Thanks, Scott. And thanks, Leslie and Frank, as well, for your time and your insights. This has been a great topic, and we really appreciate you working through even our technical difficulties. And thanks to everyone else for staying on with us. We'll make sure that if you were looking for CLE and you did not get all the CLE codes because you missed part of the PowerPoint presentation, send an email to ABI-Live@abi.org. And let us know that you attended and were online but didn't see the final CLE code for that. So again, that's ABI-Live@abi.org. And of course, everyone, the PowerPoint presentation was also made part of the materials that you received when you received your confirmation email, and we'll recirculate that so you have it. Thanks also to the Mediation Committee for hosting the webinar. And as Leslie mentioned, there are lots of opportunities for you to get involved in ABI if you're interested in mediation. If you're not a member of the Mediation Committee, please sign up. You can do that in your ABI profile or just send us an email. And also, if you're not an ABI member, it's free to you. It's not free, but the committee is free to you if you are an ABI member. So please sign up, and we look forward to meeting you. And so if you do need CLE, you'll also get an email from us, from our CLE coordinator in about a week or a week and a half, letting you know that you attended the program and giving you your credit information. And if you're in one of the states where we report to, we'll report that out for you. So thanks again for attending our ABI Live webinar. We look forward to seeing you on our next one. Have a great day.
Thank you.
Thank you. Is it just us? We lose you?